Good afternoon. I assume everyone can hear me. I've got a loud voice, and if I warn these guys, if I get too close to the mic, I start to sing, so that's a bad thing. You are in Avoiding the 10 Greatest Gaffes of Estate Planning, and my name is Adam Rood. I am a financial planner. I'm the principal of Loeb Planning Group, which is a wealth management financial planning firm in Purchase. I am joined by my esteemed colleague and friend Rita Gilbert, who is the, I guess, managing partner. Did you ever give yourself a title?
No.
No. Okay. Well,
I don't need one.
She's the chief at Hyman and Gilbert, which is based in Larchmont, and I'm going to tip my hand right here. Rita is the main attraction. I'm just the MC, really. And I was laughing because as we were preparing for this presentation, I went back and I looked at some notes. Rita and I have given some version of this presentation probably for the past 5-6 years, and every time we go through it, I learn something from her, and I hope your experience today, actually I don't hope, I know it's going to be just as good. So we're going to kick off. We'll go through some of the gaffes, some of the things that you might want to try to avoid, and hopefully at the end we'll have some time to take some questions, and we'll try to stump the band. Okay, so why don't you kick us off?
Biggest gaffe, of course, is not having a plan at all. And many people feel that I don't really need an estate plan because I have everything in joint name. I have the people that I want to get my assets to get them. And I don't want to deal with the surrogates court and probate and all of those horrible things. Well, let me just assure you that probate just means the Latin word puebate, which means to prove. And all you're doing is proving your competency at the time you execute a will. That is it. That is what probate means. So people who think it's a very difficult process, I brought 4 wills up this week for probate. It is as simple as brushing your teeth. If you know how to brush your teeth, chances are you're going to have a very easy time of doing a probate petition. Why people feel that if they don't have a plan, they'll just put everything in joint name, that is terrible for tax purposes. And it's also terrible if you change your mind about something. And, for example, you put a house with a child on it with you. Then you decide you want to sell the house. And the child says, no, I'm not going to sign the deed. You are stuck. And there's nothing that you can do short of disinheriting the child with the other assets to make the child comply. So there are techniques that we use. We use wills, we use trusts, we use powers of attorney, which is one of my favorite mechanisms for doing assets the way you want it done. We also have a gift rider as part of the power of attorney, if you wish to have it, which gives your attorney, in fact, the right to make gifts so that you could qualify for Medicaid, if that be your desire in the future. And I give them a long list of what is needed to use as an attorney, in fact. If you don't have a will, you go through intestacy. And what does it mean? It means that the state says how your assets are going to be held or going to be divided, and not you. I don't particularly like what the state says. For example, if you have one child and the child has predeceased, leaving minor grandchildren, would you want these minor grandchildren to get your money? Because if they're under the age of 18, the surrogates court is going to handle the money for the minor children or grandchildren, and that's not what you would want. I'm sure of it. So had we put a will with trusts in it, you would have named the trustee to handle the money, and you wouldn't have to worry what the state said. Many years ago, when my children were little, and now I'm a grandmother, and I don't have to worry about this anymore, but I was on a flight to San Francisco, and all of a sudden I looked out at the window and I said to my husband, "What's that orange coming from the wing?" And he said, "Oh, we're on fire." I said, "Oh, shit." And he said, "Why?" I said, "Because the wrong brother is going to get our kids." I was the shoemaker without shoes. My brother was going through a messy divorce. I hadn't changed my will. And had we gone down, he would have had my children. I'm sure he would have done all right with them, but that was not the point. It was not the time in his life that he needed to have 2 minor children. So that could have been a catastrophe. By not having advance directives, you're not dealing with the issue of incapacity. Now, none of us expect that we're going to get Alzheimer's or that we're going to be incapacitated in some way, because I've never met anybody to say, "Oh, I'm looking forward to having, Alzheimer's." But they haven't planned for it. And what you have to do is have your documents in place should that unfortunate occurrence occur. Now, 2 of the wills that I brought up to surrogates court this week was a couple who was returning from vacation in upstate New York. They got hit by a tractor trailer. The husband died immediately. The wife, after 7 days, they medevaced her to Westchester Medical Center, and after 7 days, they pulled the plug. Believe me, these people had a will that was 20 years old. They really intended to leave money to their grandchildren, but they didn't, because when they did it 20 years ago, their own children, were 18, 19 years old. So they hadn't looked, but we're going to go with the will that we have, because we don't have a choice. In my estimation, every 5 years, you should review your wills and advance directives. Why? Because the laws change, your circumstances change, and come in for a consult with your attorney. If everything's fine, you go home. If it's not, and the laws have changed, for example, right now there is pending a new law, a new power of attorney law. I don't know if it's going to pass, but if it does, I'm going to send a letter to all of my clients telling them there's a new power of attorney. Let's come in and let's discuss it. But every 5 years you would get a letter from my firm, in any event, saying just come in and let's review your documents. And clients appreciate it because they don't think about it. Nobody gets up in the morning and says, "Oh, I have to see my lawyer today because I might have to change my will." It doesn't work that way. Also, you very well might want to specify certain items of personal property that you want to go to one person or another. And for example, we have a beautiful home in Massachusetts. My son lives in California. He would never use that home. So in my will, I have devised that property to my daughter, doing other things for my son. But without a will, I couldn't do that. Everything would go 50-50 upon the second of my husband's death or my death. So that's not what you want. And you really have to think in terms of what do I want to accomplish. And for example, if both spouses had children, this was a second marriage, and one died in a car accident before the other, similar to what I just had happened last week. Now, since the wife survived, if you call that survival, by 7 days, everything is going to go pursuant to her will, not the husband's will. So you have to prepare for simultaneous death in the documents that you draft. Parents may inadvertently create a conflict by telling members of the family that they're getting certain items. And that may not be because they appear to be mean, but they forget. Oh, I promised that clock to so-and-so. I promised, my diamond watch to so-and-so. It happens. People say things, but if it's not in writing, you're causing a family conflict. And the whole point of planning is not to have conflict, to have everything go as smoothly as can possibly be. Adam?
Not surprisingly, the first gaffe that I run into from the financial planner's point of view is people not having a plan. And when I say that, I don't mean, Rita is dealing with some things that are very, very concrete. She's dealing with the law. When people are putting together a financial plan, they're really sort of trying to define the choices that they want. And what I try to encourage any client or potential client who comes into my office is to really start thinking very clearly, very honestly with themselves and with their spouse and with family members who are important to them, to think about the type of life they want to lead. And that is going to help answer some of the questions that an attorney like Rita is going to help them solve. I can't really get too much, into too much more depth because everybody's financial situation is going to be somewhat different in that respect. But just that, for lack of a better term, a commitment, a personal commitment to say, I'm going to give some thought to what really might happen to me. It's possible that any one of us may develop a long-term care need. It's possible that any one of us may suffer an early death. Although I remember when I was first studying for my insurance certifications, the instructor said that all people die exactly on time. I'm still trying to figure that out. That's probably why I'm not ready to instruct a class in insurance. But at any rate, it's that approach that says I'm going to be honest and I'm going to tackle some questions that could make us that could be very uncomfortable to answer, but they're really so critical to the life that you're going to lead. We're going to move on to the next gaffe, and Rita, as I see it, it's what happens with gift tax and lifetime exemptions and things like that? What should people be looking for?
Well, that's basically brand new under this administration. In New York, you can leave $5,740,000 totally tax-free in your estate. Federally speaking, you can leave $11,400,000 tax-free. And those numbers will change come January 1, 2020. So that just gives you some idea of the need to keep up. The gift tax exclusion is $15,000 per year per donee. So if you have 100 people and you wish to give them $15,000 apiece, you don't even have to file a gift tax return. You just give them a check, and that's the end of it. You can also increase that amount of the $15,000 by paying for an education. You can write a check to Harvard for your children or grandchildren. You can also pay their medical insurance. None of this counts towards the $15,000 annual exclusion that you're allowed to give.
Can I just?
Sure.
So if you wanted to write a check to a school for a child or grandchild, that does not count towards the $15,000. That's tax-free, correct?
Correct.
Okay.
As well as the medical insurance.
Yes. Any medical insurance premium that's paid to the insurer. You can't give it to your child and then have them write a check. That doesn't count. You've got to write the check directly to the insurance. Would you like us to take questions or?
No, whatever you like. We're okay.
Okay.
Does that payment to a school have to be for a current semester?
Well, why would you pay a school that's not a current semester?
Does it specifically be for tuition, not a donation?
Oh, right. Yeah. No, it has to be for tuition. It doesn't include board, and it doesn't include books. It's for tuition.
And Rita, just to be clear, that doesn't, when you make a direct payment like that, there's no special tax forms that need to be completed, correct?
Nope, absolutely not. God bless you.
Thank you.
So very often, we can divest ourselves of considerable money if you have a child or grandchild going to one of these very expensive schools. And I know, because, for example, I now have a grandchild who is in nursery school. And I can't believe what the tuition is in nursery school. It's what my college cost me when I went to college. But all gifts made after January 2019 in New York for a 3-year period comes back into your estate for tax purposes. That doesn't include, the tuition bills or the $15,000 annual exclusion. But suppose you give $100,000 to a child, and then you die 2 years later. For New York purposes, that's going to come back into your estate as an asset. For 1 month, from January to February of 2019, that was not the case. We had a 1 month in which we could give money and then die, and it wouldn't come back in. But fortunately, we didn't die. And now, if you die within 3 years of making this kind of any gift, other than those that are excluded, it will come back into your estate for estate tax purposes for New York. And also for the federal, because there's a line which says gifts made, and you have to include those. So you might very well want to consider. I have clients who give gifts when they're in Florida, and they give it to a child who's a Florida domiciliary. Now, I'm not sure. They ask me, do I have to include it if I die within 3 years? And I always say yes. But they say, I'm not so sure. So a lot of people go out of state and make gifts, but I can't tell you. I think as long as you're a New York domiciliary, it comes back into your New York estate. But
Isn't the New York State estate tax going to increase annually to match the federal?
yes and no. It's $5,740,000
For New York State?
for New York State,
Individually?
right? But it's $11,400,000 individually for
the
federal. So they are not the same. There is a time when they are supposed to equalize,
Exactly.
but I don't believe it will ever happen, because I don't think that depends who wins the next election. Let's put it that way, as to what is going to happen with
Who
the
is the
estate.
next election in the state, you mean?
No, for president, national,
Well, how can that change the New York State law?
because the next president can change the exemption from 11,400,000 back to 5 million,
Oh,
and then
the other way.
that's right. It can't always keep going up, and it very well could go down.
Just from my perspective as a financial planner, when we're trying to project out, what we expect to happen, and obviously we don't have crystal balls, we always operate on the assumption that taxes will increase in our lifetimes. Think of, you drove here. This is an older building, needs all sorts of maintenance and rehab, and all the roadways that we drove in on, they all need rehab. The government is going to need money. It's going to have to come from somewhere. So whether it's correct or not, we operate from the position. Best assume that your taxes will be increasing in some way, shape, or form. Hopefully we'll be wrong, but I don't think we're going to be, not in the long run.
And I have to agree with Adam, because I have, in my lifetime, never known my income taxes to go down. And estate taxes, until Trump got in, it just increased incrementally, not from 5 million to 11,400,000. And it's supposed to go up again January 1, so we shall see. But in order to maximize the gifts that you make, you might want to consider defective grantor trust, use of LLC or FLP, family limited partnerships. These are known as leveraging your annual exclusion gifts. In our litigious society, where more than half the marriages end in divorce, having some assets in trust with fairly liberal access is certainly worth consideration. I remember when my son was getting married 15 years ago, and I love my daughter-in-law, so I will say that right outright. I told my son, "You must have a prenup." I said, and he said, "No." He said, "I love my fiance, and I'm not going to get a prenup." I said, "Fine. If you don't get a prenup, I will leave all of the assets that will come to you in a trust. You will have the income from the trust, and the principal will go to your children." And he looked at me and he said, "Mom, you wouldn't really do that, would you?" I said, "Well, when you have a mother for a lawyer, don't try me." So oftentimes I suggest to clients that they do leave their assets in trust, because if you have liberal invasion powers, it's the same as giving it to them outright. But in terms of a divorce, I should say that inherited property is exempt from equitable distribution. But most people put it in joint name because they say that's what you're supposed to do when you're married. I can't tell you how many clients have said that to me. And I look at them and I say, you have just taken what is separate property and made it marital. With a trust, they don't have the opportunity to do that. So that is why I often suggest trusts to clients, so that I am sure that what I worked so hard for all my life will go to my children and my grandchildren, and will not go to an ex-spouse. It happens all too often. You're up.
Your son do the prenup?
He did.
Is he still married?
Yes, and I still love my daughter-in-law, and I love my 2 grandchildren. But it was something that I insisted upon, and fortunately, he saw the light at the end of the tunnel.
I'm not going to argue with that.
Rita, so are you suggesting in every case that real property be in one spouse's name, not jointly?
Well, it could be as tenants in common, where each of them owns a 50% interest, especially, and I really didn't talk about credit shelter trusts, which we always used prior to this $11,400,000 exemption. But in this way, we could shelter at least half of the house on the first to die. Now, if a couple comes to me with $1 million or $2 million, you can really leave it outright as opposed to trusts. But when they talk to me about their children, that's when the second to die, I put things in trust, as opposed to the first to die, which is what I was doing before the law changed.
Okay. I'm actually going to skip my next one. What are they? I defer my time. I cede my time because it's really much more about retirement planning, and that's a little less appropriate for us today. Let's talk a little bit about the importance of naming a fiduciary. And the importance of that person, who, what their role is, from the legal perspective, what should the person who is doing the designating, what should they be looking out for?
Well, first of all, they should look for someone with some financial acumen. I feel that appointing your spouse, who may not be very financially astute, alone may not be the right move. Amongst my older clients, I usually will suggest, obviously it's their wills, so they decide. I usually suggest a surviving spouse with a child, so that if the surviving spouse has issues of mental capacity, that at least the child can take over and administer the estate. I strongly believe that you just don't name your neighbor your best friend because they are your neighbor, your best friend. Give a lot of thought to the independent person you choose, especially if you're drafting, for example, a will and an irrevocable trust. We usually use irrevocable trust for life insurance because that can escape taxation in a spouse's estate and in your estate and a spouse's estate and go outright to children. Insurance is taxable. Even though most people say life insurance, that's not taxable. Oh, yes, it is. If it's not in an irrevocable life insurance trust, it is a taxable asset. So my feeling is you should never own life insurance in your own name, other than a veteran's policy with a $5,000 or $10,000, face value. Because why would you want to have a spouse subject to taxation when you don't need to have it? They have all the use of it. They have the right to income. They have the right to principal invasion, as long as it's done by the independent trustee, who's going to be your child in most cases. And so choosing a fiduciary is a very important part of estate planning. And I do tell people, tell me a little bit about this person that you're naming, so that I have an idea of how this person is going to operate when the person in front of me is no longer here. And then I would make some suggestion. But having life insurance owned by an individual is a terrible gaffe in estate planning, because believe me, the government will get its pound of flesh.
Does everybody in the room understand what a fiduciary is? What that person's role is to be? A fiduciary is someone who is literally putting his or her interests aside. It's the interest of the person or the entity that they're responsible for. Those are the interests that prevail. They have to come first. I'm in an industry in financial services where we are asked to be fiduciary. We're asked if we are fiduciaries and if we're adhering to fiduciary standards. It's slightly different from a legal perspective, but the kind of the morality of that role, that really is present. That person has to care for whoever it is or whatever it is before their own interests even enter into the equation. Every day.
You said life insurance is taxable. Does that include term insurance?
Yeah, any insurance that goes into your estate is taxable if it's not held in a trust for the benefit of, it could be a spouse, it could be a child, but yes, life insurance is taxable.
Is it only taxable if it exceeds the threshold that's taxable in the first place?
Sure. In other words, if
you're less than 5.4 million, whatever it is, it doesn't matter.
That's correct.
And it is estate taxable. It's not income taxable. Okay, so there is a distinction to be made there.
Could you explain the difference when you say estate tax?
I'm sorry,
No, he said that there's a distinction between income tax and
Right.
estate tax.
like your
Can you
earnings.
explain the difference?
The question is, what is the difference between income tax and estate tax? Can Adam explain that?
Okay, so for income tax, every year we're all filling out our forms 1040. We're reporting income. That's income tax. But as Rita spoke of before, you have the 5.7 million for New York State, 11 million and change for the federal government. Those are the taxable thresholds for estate tax. Okay, so if you have a life insurance benefit that is, $5 or $11 million, or it pushes the estate over that threshold, it's all taxable dollars to the estate. The person receiving the benefit, they're not going to be taxed on it as income, but the estate will be taxed.
But if it's below that, it's not taxed if it's below that.
If it's below that, it's not taxed. But from a planning perspective, given that we don't know how estate tax law will change in the future, and we've already stated that our assumption is that taxes will go up, it's best if you can put that into what is known as an ILIT, really a irrevocable life insurance trust. That way you avoid that tax. Why create a problem if you don't have to?
Yeah.
If I have an estate, say $6 million, is my tax on the first dollar or the dollars between 5 and 6?
Well, first of all, in New York, I should explain to you, we have what's known as a cliff. If you're 5% over the $5,740,000, you fall off a cliff. And what that means is that you're taxed from your first dollar.
That's what I thought.
So what I'm doing, and if I have people, say, with $12 or $13 million, I take the first, whatever the New York exemption is at the time of death, I put that into a credit shelter trust so that doesn't get taxed when the second to die happens. And therefore, we have saved, in effect, $11 million plus of estate tax. If you leave it all to the spouse, and then say, for example, that $6 million grows to be $8 million when the spouse dies, you will have a hefty New York estate tax because of the cliff. You'll be taxed from the first dollar that you die with.
Play again? All right. Every now and again, I will have somebody who comes to me and they ask me to put their non-retirement, or what we refer to as non-qualified assets, to make them TOD, transfer on death, so that at the time that they die, that whatever assets they have in those accounts goes directly to their beneficiaries, whether it's their children, their friends, their first spouse, whatever. What's the potential pitfall there?
Well, first of all, if everything is in a TOD account, what are we going to use to pay your expenses? Don't ask a child to return money to an estate after they've figured out how they're going to spend it before they even got it. And the minute they get it, they've already done things with it. So that's another gaffe, is failing to provide for estate liquidity. If everything you have goes into a joint asset, there is nothing to pay your funeral with. There is nothing to pay your real estate taxes with, your electric bills, whatever debts you may die owning, because all the money went to your kids. They went to the bank with a death certificate before you could say Jackie Robinson. And they went and they collected the money, and boom, it's either in their accounts or maybe whittled away. But there's nothing left for your expenses. And so I never suggest that everybody put, you want to put one account or two accounts, especially retirement accounts, that's okay. Because you name a beneficiary and then you name a contingent. But the other assets, I want to have a liquid estate so that if there are debts to be paid, that I have the money to pay it, and that I don't have to go back to the kids and say, by the way, mom or dad owed X dollars, you've got to cough it up because you collected all the money. Chances are they're not going to do it. And you don't want to be in that situation.
But then what happens if there is no money?
And you're dead.
And you're dead?
Yeah, that's what I was thinking, yeah.
Well, then there'll be a claim. There'll be claims, and if they can prove that your kids got the money, chances are they will sue the children. Especially if you were in a nursing home and they signed the admission agreement. Oftentimes, even though New York says you're not responsible, the nursing homes don't know that. They will sue you. And I've had that happen on many an occasion. The other gaffe that I find just disconcerting, and somebody, when I was doing the consulting outside, said, well, I don't really need an attorney. I'm going to go on the internet and I'm going to do my own will. And I said, if you had an illness, would you self-medicate? And she looked at me and she said, why are you asking me that? I said, well, by going on the internet and doing your own will, you're self-medicating. And you know something? There's no do-overs with wills. Once you're dead, you can't come back and redo the will the proper way. So don't be penny wise and dollar foolish. Go to a lawyer and make sure that it is done properly so that we don't have to worry about doing it incorrectly.
Excuse me, I just wanted to ask a question about the TOD. So when you say liquidity, you mean so you don't have a beneficiary on the account?
No.
So if you have a, let's say you have
Repeat
an
the question.
account.
She is asking about a TOD, a transfer on death designation. When you set up such a designation, you're saying you're establishing beneficiaries for non-retirement, non-qualified assets, similar to what you might set up on a retirement account. But what Rita is getting at with the liquidity there, and I agree with her completely, is your estate is going to have some residual expenses. Everyone's estate will, for the hospital, nursing home. Well, funeral homes, they get paid, and they take Visa. But your estate will have some bills to settle. And yet, if you've determined that all of your assets should travel first to your children or whomever you've designated, you've basically skipped out on a bill. So you want to leave some money in your estate to handle those final expenses, and some of those expenses can be considerable.
So you don't have a...
Would you recommend purchasing a pre-burial plan and a burial plot prior? I mean, now while we're alive.
It's one solution, and it solves a lot of problems for a lot of people. Sometimes they're available through different lodges and different types of organizations.
Funeral homes also have that.
Yeah, when my dad, he should rest in peace, passed away, he had a plot, and actually, but it was within a family circle, and unfortunately, my father's family people didn't talk to each other very well, and it ended up being a little bit messy. But fortunately, we were able to resolve it. If there's an overriding theme that you're picking up on here, it should be that the more you can plan for in advance, within reason. You don't need to pay every last expense or do every last detail, but approach things with that kind of eyes wide open. Yeah, this is going to cost money, and if I can take care of it now versus later, not a bad idea.
As a matter of fact, on that theme, I have said to my husband, not only do I want to prepay our funeral expenses, I want to put the stone up because I don't want my children. I had a beautiful stone for my dad, may he rest in peace, and I want to match that stone. We bought a plot after he died, so we have 12 graves very close to where he is, and I want the two to match. So my husband said, only my wife would think things like that. And I said, hey, you know, we got to spend the money sometime, so I might as well have what I want.
In what form do you're talking about liquidity? You're talking about putting $10,000 in the bank or some other kind of...
That could work. You know, some sum of money that will cover what are presumed to be those final expenses. 10,000 is burials can cost quite a bit.
20,000, 50,000.
Yeah.
What form other than the bank or
a small estate in New York is $30,000. So if your assets are under $30,000, you can do what they call a small administration. And it used to be $5,000. So I guess they've realized that things cost a little bit more than they used to. So, I mean, that would give you immediate access. You could put that in joint account with one of your children.
Do you have any literature up in front that gives that information to take home?
That's from the previous presentation.
All right.
So I was going to answer the same question. So do you put this amount of money for the expenses of your funeral in the trust, or is it a separate private banking account? I mean,
it depends on how we've done your estate plan. If you don't have a trust, and you will, you might very well have a joint account with one of your children. And with the specific stipulation, and you tell the other kids that this is money that I have joint, and it's to be used to pay for my funeral, for the stone, for the rabbi, for the priest, whatever you want, and assuming that the other children will see that that is how the money is used.
So it's still a TOD account?
It could be, or it could be a joint account, because there may be some expenses while the person is alive that might need to be paid.
Think of it as the petty cash envelope that you might keep around the office.
Good analogy.
Are you still responsible for student loans after you die?
If you have an estate, yes.
Yeah. Yeah. In fact, I have twin boys who recently graduated from college, and actually, when they fortunately got good jobs out of school. And they said, do I need insurance? And I said, absolutely, because you do have loans, and this way, at the very least, take care of those loans. You know, it's they can come back to bite, and there are some people who have considerable debts, and their families are dealing with that.
How long what's the average probate time?
In Westchester County, probably a month.
And I'm asking because I'm the POA for my mom and her caregiver, and she is quickly outliving her money. She's 94 right now. And I'm worried about that, and she can no longer sign anything. She could until a few months ago. So I went to her bank, and I was depositing from her one account that she has left of money into her checking account, where I pay now for the skilled nursing. And they told me, which I was shocked that POA is only as good
till she's alive. Correct. The minute she stops breathing, that's it.
When something happens to her, then I can't write a check to the place that she's in or any place.
As a matter of fact, I am currently a named executor on her client's will. She had no family whatsoever. I've been representing her since 1985, and I was her power of attorney. And she passed away very suddenly. She was on her way back to her home, and she died in the ambulance, coming back home. And when I went to the funeral home to make the arrangements, they insisted that I pay the out-of-pocket expenses, which came to over $3,000, to open up the grave, to pay the pallbearers and the priest. Nobody ever asked me before to prepay from my own money, but I had to do it because her will wasn't admitted to probate. She had just died.
Right.
And the funeral home wouldn't conduct the funeral, and this is where she insisted, even in her will, she put in that I want to be laid out from this funeral home. So I wasn't going to go against her wishes. It just cost me a little bit of money.
So is it a good idea then to change the POA, but my mom can't sign anything though, to a joint account?
Yes.
And how do you do that if she can't sign?
Well, that's a problem. When you basically take the money out as POA and you open another account with your name and her name, and if she can't sign, then put it in your name, and then you use the money as needed.
So you could designate that account for funeral, et cetera.
For paying
Right,
her
and you could
expenses.
call that a convenience account. People often have convenience accounts. There's more litigation over convenience accounts because people say, oh, Mom expected that I would have the money after she's gone or whatever. And that wasn't the intent at all. It was because Mom couldn't get to the bank anymore and asked you to basically be her power of attorney, but without a power of attorney. Just call it a convenience. And now the banks have started designating convenience account right on the whatever, the application, so that they know that it's for convenience purposes.
What happens if you die without a will?
You die intestate, and then the laws of the state take over. So,
My estate would go to the state?
no, your estate, do you have any family? There is nobody, no brothers, sisters, then you have an issue. As a matter of fact, I just happen to have with me, which I pulled out this morning, the laws of intestacy. And here it is. And it's 411 of the EPTL, the Estates, Powers, and Trust Law. And it says, if a decedent is survived by, then they say a spouse and issue, a spouse and no issue, issue and no spouse, one or both parents, issue of parents, one or more grandparents. You don't have any of this.
No.
And a distributive, the right of an adopted child is the same. So in effect, you may very well be giving the government your money. Because under the laws of intestacy, if there's nobody who survives you, no aunts, uncles, sisters, brothers, nieces, nephews.
I mean, my estate would be my home. That's it, primarily.
Well, I would think that you would want to have designated charity of your choice rather than the state to get your.
Use the money more.
As a matter of fact, I had a situation like that where we sold, if you will, we gifted the house to Greenwich Hospital with the intent that Greenwich actually paid the expenses of the house, but upon this person's death, Greenwich Hospital got it. And so there are lots of things you can do to so that it doesn't go to the state.
You have to have a will. Right?
Yes.
What's the saying that we generally hear? That if you don't have a plan, the state has one for you. So you get to, this may be the last set of choices that you get to make. I'm going to ask the next question, and I'm going to ask it of everybody here. When was the last time you took a look at your beneficiary designations, whether for your retirement accounts, your any insurance policies you might have. Don't all raise your hands at once. Okay. This is a problem. This is a significant gaffe, and people just tend to forget about it. But if you've managed to save any amount of money, and it's important to you that it goes to the people that you care about, the people that are important to you, it's worth revisiting those choices every now and again. In my practice, we try to at least have people take a look at least once a year, because everybody's life changes. It's really very simple, and if somebody, has either passed away or your relationship with them has changed, has deteriorated, it may be worth, it's easy enough to change those designations. We had a case where a husband and wife, they were absolutely convinced that the wife would predecease the husband, and he had set up so that everything that he had went to his children. The problem was that one of their children predeceased him, and then he went, and against everybody's prediction, he predeceased his wife, and the assets bypassed her, and she needed them. Fortunately, the surviving child was a good soul, and he recognized what needed to happen, and he disclaimed the what was his rightful inheritance. But it's problematic, and it's so simple to solve. So do take a look, and also if you've got powers of attorney that you established way in the past, as Rita said before, bring them up to date. They need to be checked out.
When a couple marries and one of the spouses has a lot of student debt, does that other person responsible also for that debt, or does it remain separate?
Please repeat the question.
The question is, if you marry somebody with a large amount of student debt and that person dies, is the surviving spouse responsible for that debt?
Yes.
And I don't believe so.
No.
They didn't sign on it. So in order to be responsible, I would think that you would need to sign for that debt.
My daughter married a doctor.
And I just want to end with something that John Lennon said, and I think it's so true. And of course, I'm a big John Lennon fan. It says, "Life is what happens to you while you're busy making other plans." And how true is that? So, but any other questions, Adam and I would be very happy to answer.
Something you said about life insurance and not put your own name on it?
That you should not be the owner of it.
You shouldn't be the owner of the life insurance.
So who would be the owner, since I'm paying?
No, it should be your life insurance trust.
Also, you should put it in a trust.
Yes,
Oh,
life
thank you,
insurance.
sorry.
Life insurance is definitely an asset that belongs in a trust, so that it escapes to estates and then goes tax-free to your kids.
It would seem that it's a good idea to go to a funeral home of your choice and chew the fat with them, so that you know how much money to put in this slush fund.
You could.
So that you can also nail down what you really want. I myself want a pine box, and they're going to try to talk anybody else up to, a mausoleum. and to put that specifically then in your will after a discussion with the funeral home.
It doesn't belong in a will. Funeral instructions never belong in a will, because nobody looks at the will till you're dead and buried. And if you really want to be cremated, you're out of luck. That's what you should do, is just prepay the funeral home.
I'm not talking about prepaying. I'm just talking about knowing a ballpark.
Oh, yeah.
Yeah, well, first of all, I just had one of the estates that I just probated. Somebody had to put up an additional $300. Why? Because when he prepaid his funeral, it was X dollars, and now it's Y dollars. So the daughter had to pay an extra $300. So I'm just saying that funeral instructions just don't belong in a will.
Just as an aside, if you do pay those pre-planned complete, then it locks in that price.
It's supposed to.
Yes.
Except I don't know why when this person just came to me, and she signed the papers this morning while I was here, she said she had to pay an additional $300. I don't know why.
Some people do it in the installments, and they will accept that, but unless it's paid in full, it is not locked.
Again, I don't know the situation. I just know that she put down that her expenses were, that she wanted to be reimbursed the $300.
Question, because, you know, caskets, funerals, all that, it's all a business, and those things happen to you at an emotional time. When somebody passes away, what is the logical next step? So you're not taken in, you know, are there pitfalls to...
I'll tell you what a lot of my clients do.
Yes, please.
When they lose a spouse or a parent or a child, they call me. They make me go with them because they think that the funeral home will pull the wool over their eyes, and they're too emotionally distraught to think clearly. They say, Rita, we trust you, come with me. And I go. I mean, I've planned more funerals in Westchester County. My husband says I should be an undertaker, not a lawyer. But it's true, because I have planned lots and lots.
Now, there seems like, is there a trend, or because kids are in college and they're all over the place, that people aren't, they're not doing the traditional funeral part, they're doing like going straight to a memorial, which may not happen for a few months?
Well, that depends if they're being cremated, because you can't keep a body for a few months.
Right.
Yeah, I've had a lot of clients recently choose cremation as opposed to, you know, traditional burial. But again, that's a choice. And usually they will give me a letter as to what they would like to happen, so that if I open my file, I can tell the family what their parent wanted.
But you can have a burial and a memorial service.
Oh, absolutely.
So it doesn't, you don't have to have...
No, one doesn't preclude the other, but sometimes to save money, they have one or the other. By the way, anyone who wants, we have business cards up here, and we just have something about myself as a super lawyer in Westchester.
And she is a super lawyer.
God bless you. Thank you.
Thank you.
Thank you, everyone, for coming.
Thank you.
Thank you.